Trinidad and Tobago against Harridath Maharaj.
Yes, Mr. Carter.
My Lords, there are two issues in this appeal. The first is what must be established to prove the tort of malicious prosecution. That I can say the ingredients to that are largely agreed. The outstanding issue, or perhaps an issue of inference, is the extent to which, once it is established that there is no reasonable and probable cause for the prosecution, whether that is sufficient from which an inference of malice can be drawn, or whether malice has to be proved by other extraneous facts. The second issue in the appeal is whether the Court of Appeal, in overturning the High Court judge's judgment, exceeded its powers as an appellate tribunal in order to substitute its own view of the merits of the case for that of the High Court. My Lord, on that second point, we, and no doubt the Board, is materially assisted by two recent decisions of this Board in the cases of Stewart and the Water and Sewage Authority against Sahadar, which are respectively tabs 26 and 27 in the bundle of authorities, and I'll come on to those later.
We're going to be using purely electronic authorities, so all you need to do is to give us page numbers rather than tab numbers.
My Lord, I should be doing the same, and I have tab and page references during the course of my argument. I hope that will suffice.
Good.
Yeah. So, malicious prosecution, first of all. What is needed to establish the tort of malicious prosecution is, first of all, a prosecution which was unsuccessful, and a prosecution that was brought in the absence of reasonable and probable cause by a prosecutor who acted with malice, and inferentially malice as against the accused. As I say, the parties are fundamentally agreed about the basic principles about the absence of reasonable and probable cause, which we submit is a matter of fact and judgment, so a matter principally of evidence. When it comes to malice, the question then is the extent to which, if absence of reasonable and probable cause is established to the satisfaction of the tribunal trying the case, whether that tribunal's assessment of the character and credibility of the prosecutor is sufficient to enable that tribunal to draw the conclusion that the prosecutor was influenced by malice, which we submit in the context of malicious prosecution has an autonomous meaning and is not the same necessarily as malice in criminal law. On the second issue, did the Court of Appeal exceed its powers in overturning the findings of the High Court? Our submission in summary is this. This was a case which, in some ways, the issues were fairly balanced. The High Court could have found in favour of the respondent, but it did not. And that's the function of a High Court. It is the function of a High Court to determine disputed issues of fact and evidence and to draw its own conclusions based upon its assessment of the evidence it has seen and heard, as well as other evidence beyond that of witnesses who have given oral evidence, and to draw its conclusions as to what inferences it can draw from its own factual assessment of the witnesses, and from that draw its conclusions and reasoning as to what follows as a matter of law. In other words, you move from evidence to inference to legal conclusion. And that, in my submission, is what a good judgment looks like. It starts with a summary, not a recitation, but a summary of the relevant facts. An assessment of what facts in turn that assessment leads the judge to conclude, followed by what inferences can be drawn from those facts, which lead then to conclusions of law which provide the outcome to the case. And the fact that a court of appeal may, had it been hearing the evidence, taken a different view is neither here nor there, and it is no business of the Court of Appeal to substitute its own preferred view for the findings of the High Court judge.
I mean, is there any dispute between you as to that as a point of principle? What said, as I understand it, against you?
Point of principle, my Lord, no.
Yes.
However, one of the points made by the by the respondent, is that the trial judge placed too much emphasis on the evidence he heard and his assessment of the witnesses, and that's at paragraph 42 of the respondent's case. And that, we submit, is a bold and insupportable submission as to what is and what is not within the remit of the trial judge.
But again, does it go that far, or is it rather that one must be careful not to imbue the prosecutor with the hindsight that may be derived from having heard the witnesses actually give evidence?
Can I read paragraph 42? It's page 1003 of the record.
Sorry,
1003, my Lord.
Thank you.
It's tab 5 of the core bundle, if for those of you who are using the core bundle. So paragraph 42, the respondent would respectfully add one further criticism, which is that the judge placed too much weight on his impression of the oral evidence before him, and on his findings that the appellant and PC Harridath were telling him the truth about the events of the 30th of August 2003, and Mr. Jagannath was not.
Well, it has to read that with paragraph 43. You have to read that with paragraph 43, I think. Do you not?
I agree, yes. So while according respect to the judge's findings as to the witnesses before him, the respondent submits that the true question before the judge was what ASP Philip was to make of the accounts of these men and all of the relevant witnesses at the time of his investigation. We agree, and that is precisely what the judge did. So having assessed the evidence and the credibility of the witnesses, he then said, as to the credibility of the witness as Harridath, that this was a witness whose evidence and whose patent credibility should have been manifest to Mr. Philip. Mr. Jagannath was a witness who was not frank. That was something, due to Mr. Philip's dealing with Mr. Jagannath quite extensively, Mr. Philip should have been aware of, and the flaws in his evidence. And Mr. Philip himself was a witness who the judge did not find impressive. So when it came to assessing what it was, the correct test, namely what did Mr. Philip know, what did he believe at the time he A, instigated the prosecution, but then B, thereafter, up until the hearing and the conclusion of the proceedings, what did he know, what did he continue to know? Was his assertion that he had a reasonable and probable cause for prosecuting? Was that correct? First of all, was he...
It's the final sentence of 43 that you presumably are taking issue with. The other side is saying it's barely material, the judge's findings as to credibility, if at all, and you're saying it's relevant.
Of course it is, because if it is obvious that a witness's evidence is full of gaps, and would have been evidence, as the learned judge said, to Mr. Phillip, then the judge's assessment of a witness is relevant to whether Mr. Phillip had reasonable and probable cause for thinking that the court would and could rely upon the evidence of that impugned witness. In other words, if the evidence is full of holes, and it is obviously full of holes, a prosecutor has no right to say, I'm entitled to rely on this because I can rely on the curate's act principle, that there are bits of it which are okay, without doing a proper assessment of the real test is, will this evidence stand up in court, not necessarily to lead to a conviction, but enough to cause the court to say, there is a case here for the defendant to answer. If the reality is that the evidence, when subjected to reasonable, objective assessment, the kind which an honest and responsible prosecutor should undertake, if it falls apart or has obvious gaps which cannot be filled, then the prosecutor is going to say, reasonably and objectively, I cannot proceed with this case because I cannot expect a court to find there is a case to answer. And that, I've expressed it differently, but that, in effect, is what the learned High Court judge was saying.
But how does the... Sorry, go on.
I was just going to say, could you show us where the High Court judge got with that?
Yes, my lord.
Came to that conclusion.
Yes, my lord, I will.
We don't want to take you out of your course because there's a risk that one's going to jump around here if one does, but certainly for my part too, that is a very important part of the analysis, because the submission that you've made so far may be thought to be unobjectionable if the judge approached the matter correctly.
Yes.
That's, as I understand it, where you fall apart.
Well, I will leap to that straight away if you'll give me a moment to find my part in the notes. Yes, my lord. His assessment is at his judgment, page 352, core tab 6. And from paragraph 13, through to paragraph 29, he deals with the evidence that was given before him, and then he goes on to deal with the evidence which was given before the magistrate's court, which was available to him.
I think what I was asking for, at any rate, is where the judge finds that Phillips should have formed the same view of the witnesses
Yes.
as he did.
Paragraph 19, page 354. So, as stated earlier, the court was impressed by the evidence of Harridath, that's the police officer who gave evidence in support of the appellant, and whose statement had been taken and was available to Mr. Phillip before the prosecution commenced. The court was impressed by the evidence of Harridath, and there was no reason why, in a balance of probabilities, that the version of the events of the 30th of August, as presented by him, should have been rejected by this court. Given the nature of the information allegedly received by the complainant, that's Phillip, in the said conversation, and having regard to the fact that the information was contained in the statements which were submitted to Alfonso, That's the appellant's scene. The claimant is Maharaj.
Yes.
The complainant
yes.
is Philip.
Yeah.
The prosecutor, as it were.
The prosecutor, yes. And so, if I can just, by way of
So
parenthesis...
it says, given the nature of the information allegedly received by Mr. Maharaj in the said conversation.
The statements should have been considered by...
The complainant, yes.
Yes, by Mr.
Phillips.
By Mr. Philip. Sorry. So what he's saying is this was evidence of a credible witness who substantially undermined the prosecution case, whose evidence was available and should have been considered by Philip. And had it been considered by Philip,
So, what statements is he referring to there? The statements should have been considered by the claimants. These are, I think they're the statements in paragraph 18, aren't they? The claimant, Dinu, and Officer Harridath
That's right.
Maharaj. So, is it said they were not considered by the complainant?
no, it's not said that they were not considered. It said that had they been assessed properly, the complainant would have realised that the case was fundamentally flawed. In other words, the complainant should have predicted the outcome of the hearing before the magistrate.
I mean, he says they should have been considered by the complainant, which led me to wonder whether it was suggested they hadn't been considered. But you're not saying that.
I'm not saying because it was available to...
Yes, quite.
Yes.
One would assume the prosecutor had read the statements and considered them, but the judge seems to be saying he didn't consider them.
Well, I think what you need to interpose there is
Yes.
considered properly.
In the sense of making further investigations.
Exactly.
So,
Or considering what was said by those in those witness statements compared what was said by the principal witness for the prosecution.
so he's saying that the complainant should have thoroughly investigated the issue as to what happened on the 30th of August and should have interviewed Harridath Maharaj.
Well, he says he did interview Harridath Maharaj at the last sentence of 19. The complainant said he did interview Harridath Maharaj, but that was not presented as evidence before the magistrate's court. That was exculpatory evidence on behalf of Mr. Maharaj, of which the complainant was aware, but was not used at the magistrate's court. Is that
What I don't understand is, did Harridath Maharaj give oral evidence at the magistrate's court?
No, that's the point.
I see. Can you actually maybe able to help me on a matter of criminal procedure in Trinidad?
Yes,
I get the impression from the judgment that prosecution witnesses' statements are not disclosed, but they give evidence, and they're only disclosed if their oral evidence differs from their statement. That's something I sort of deduced from the judgment. Is that correct?
Criminal procedure has changed over time.
Yeah, but at the relevant
We're
time.
going back to 2004.
Yes, so what was the procedure
The
there?
procedure was that statements of witnesses who were called should have been provided to the defence. Witnesses who were called.
Who were called?
So,
But
I mean,
this observation in this last sentence of paragraph 19 doesn't stop at saying, well, no statement was produced at the trial in the magistrate's court. He said, no statement was produced to this court. Now, I imagine that the ordinary process of disclosure took place in these proceedings, so that if the complainant, Officer Phillips, had taken any statement at all, even when he chose not to use it at the trial, it would have been disclosed in these proceedings.
yes, it should have been.
I think I'm reading that as casting doubt in the judge's mind about whether the complainant really did interview Mr. Harridath Maharaj.
My Lord, it's exhibited to Superintendent Phillips' statement. It's page 731.
Page?
That's Mr. Phillips' statement, and Harridath Maharaj's statement that the superintendent took is exhibited at page 825.
825. So was the judge just wrong to say that no statement from him was produced to this court?
He's wrong on that, yes. It was part of the disclosure process.
Where is the statement that we're talking about?
825.
825.
Yeah.
Yeah.
Which is why I was inviting the board to conclude that when the judge said should have considered, what he meant was not should have found out whether there was one or taken one, but should have considered the effect of it before charging or before continuing with the prosecution.
But he says that Harridath Maharaj should have been interviewed. But he was interviewed.
Yeah.
Well, there's a difference between taking a witness statement and interviewing.
Really?
Harridath Maharaj was a police officer who could well have provided his own witness statement. There's a difference between...
Well, not according to the statement, which is given to Mr. Phillip, Officer Phillip.
But again, there's a difference between producing a witness statement and deciding whether you then, as a result of considering the witness statement, whether you make further inquiries of that same witness or of other witnesses. Now, it may be that I'm reading too much into it. It may be that the judge has simply made an error and had overlooked the fact that
this statement is the same as the statement that was made on the 11th of September.
Yes.
To Mr. Maharaj
Yes.
by Mr. Harridath Maharaj, which supported his version of what had happened insofar as Officer Harridath Maharaj was able to.
Yeah, that's correct, my lady.
And this says the same thing.
Yes. So that's why, having been provided with a witness statement, which was drafted by the witness himself, being a senior police officer, and simply then put in the file, and why was it that Mr. Phillip effectively decided to ignore it for the purposes of assessing whether there was reasonable and probable cause to prosecute Mr. Maharaj and to continue with the prosecution of Mr. Maharaj?
I think what he's saying is that there should have been further investigation. I mean, I agree that the said statement should have been considered by the claimant. It may be a bit ambiguous.
Yes.
It may not be he didn't have them before him, but he should have looked more closely at them. But what he says is that the complainant should have thoroughly investigated the issue as to what transpired on the 30th of August 2003, and then in doing so, Harridath Maharaj should have been interviewed. Well,
Yes, quite.
And Danu should have been questioned. So that's what he's saying here, isn't it? That, and that sort of, I suppose what you deduce from that is that having failed to take those steps, the prosecutor couldn't have reasonable grounds for initiating and continuing the prosecution.
Right, my lord. Now, of course, Harridath Maharaj was never going to be part of the prosecution case
No.
because his evidence undermined the prosecution.
Well, in England, he might be part of the prosecution case.
If he was prosecuting, I would have regarded it as my positive duty.
Yes, indeed. But I mean, that's a different one. But
That's a
he
different-
would have been a witness. I mean, it's pretty obvious that the defence would call Harridath Maharaj, isn't it?
Yes, but and the question begged and posited by the judge and amplified at paragraph 35 at page 360. Given the factual matrix in this case, and given that the complainant was at the time an assistant superintendent of police, a more thorough investigation should have been conducted prior to the institution of the charges. the complainant had informed that the claimant had information that the claimant, in other words, so Mr. Philip, I'm going to use names. It's very difficult when courts use respondent, appellant, claimant, complainant. Mr. Philip had information that Mr. Maharaj had alluded to possible misconduct on the part of senior politicians and officers of the state. There were contradictory statements from both Dinu and Ramesh Nareen, and there was no direct evidence that linked the claimant to the offence, Mr. Maharaj to the offences for which he was charged. Based on the evidence that was presented at the Magistrates' Court, it simply cannot be said that the complainant could have formed an honest belief in the guilt of the claimant. There were glaring gaps and deficiencies in the evidence. An officer with the seniority that Philip had at the time should have exercised a greater degree of caution and should have conducted a more in-depth and detailed investigation. And then he goes on to say whether the matter should have been referred to the DPP, particularly in light of the allegation against a minister. But that's a different matter.
When it says based on the evidence that was presented at the Magistrates' Court, that's a reference, isn't it, to the oral evidence? To the oral evidence.
Oral and written, because some of it was statement. And also, there were photographs and there was an expert's report.
Because the case didn't get further than halfway, we don't know whether Officer Hari Prasad was going to be called or would have been called by the defence, or do we know that?
We don't know that.
My lady, we know who was intended. That's page 6 of the notes. The defendant's witnesses are listed in the notes at page 6.
And is he one of them?
Yes, he is, my lady. Harry Prasad, yeah.
The point being made by the judge at paragraph 35, when he draws it all together, is that given the evidence that was available to Mr. Philip, would a reasonable objective observer, the test that's used as reasonable probable cause, have realised that the case was so flawed that it was not going to survive the hearing in the Magistrates' Court? And query whether he should have realised it wouldn't even survive a submission of no case to answer.
So what Officer Philip knew was that Hari Prasad, in two statements, one on the 11th of September and one that January statement, 2004, had supported Mr. Maharaj's version of what had happened, and he was on the list to be called, so he could have foreseen that that was evidence that was going to be given, and that was something he should have weighed in his mind when considering how his case was going to stand up. Is that what you're saying?
That's part of the argument. It's not the entirety, but it is part of it, bearing in mind as well the status of Mr. Hari Prasad as a senior police officer, as opposed to a witness who might have given it, as was the case in the prosecution witnesses who've given contradictory statements.
Hari Prasad was a senior police officer, was he?
Yes.
What rank? Sergeant. Yeah, and the appellant here today, what rank was he?
Philip was assistant.
No, sorry, your client.
Inspector.
Inspector, thank you. Thank you. So Hari Prasad was the sergeant and...
Yes.
Yes, right.
And Dinu was the corporal.
Thank you.
So there are two stages to the assessment that should have taken place according to the learned judge at paragraph 35, which we submit is the correct approach. You have to look at it through the lens of what Mr. Philip knew at various stages of the process. What did he know at the time he decided to start the prosecution? Not the investigation. What did he know at the time he decided to prosecute? And if he had reasonable and probable cause at that stage, then he cannot at that stage be liable in tort for malicious prosecution, because there could not possibly be a cause of action if he had reasonable and probable cause at that stage. However, there is a continuing duty of a prosecutor to review the evidence to ensure that the evidence remains, and the case remains such that there is a reasonable and probable cause to believe that it will survive a submission of no case to answer. And it's interesting that the Code for Prosecutors applies apparently in Trinidad and Tobago as it does here.
The what does, sorry?
The Code for Prosecutors,
Okay.
which requires a continuous review.
Yes.
So, for example, if the only eyewitness to an offence disappears,
Yes.
and the prosecution know that witness is not going to be available, it's subject to admissibility hearsay issues,
Yes.
then the prosecution would have to decide whether the case could now reasonably be expected to survive a submission of no case.
Are you able to give us a reference to that? You don't need to take us to it, but can you give us a reference to that?
I can. It's Williamson and the Attorney General. It's tab 8 of the authorities. Of the record, sorry. Page, yes, of authorities, page 1178 of the electronic record. And it's in paragraph 9.
Yeah, thank you.
You may be going to address us on this, but what is the relevance of the fact that the case did not survive the submission of no case to answer at the magistrate's court?
That is the second ingredient of the tort of malicious prosecution. There was a prosecution and it failed. The significance of it is that not that the accused was acquitted, but the accused, the court found there was no case to answer. In other words, there was a serious flaw in the prosecution evidence.
So in your submission, it's absolutely central evidence that the case did not survive that half-time submission in the magistrate's court, because you might say, might you, that what proves there was no reasonable and probable cause is the fact it didn't survive the half-time submission. It's not that the case went ahead and the defendant was acquitted. It's actually, it didn't even get past half-time.
Yes.
There was no evidence to put before, well, it's a magistrate, but to get beyond half-time. Isn't that absolute proof that there was no reasonable and probable cause?
At that time, yes. The question then is, that's why I go back in time and say it's a staged process. Was it predictable, reasonably foreseeable to Mr. Phillip that would be the state of affairs at the conclusion of the prosecution case in the magistrate's court? If it was, then there was no reasonable and probable cause to prosecute or to continue with the prosecution. If, however, it could be established that Mr. Phillip did have reasonable and probable cause and something changed during the court post-charge and prior to the hearing at the magistrate's court, then you would have an assessment by the trial judge. The judge would have to decide at what point did his knowledge cease to be reasonable and probable and become unreasonable.
If I can see that if a witness doesn't come up to proof, for example, that would be a critical factor.
It would.
But just on the assumption that that did not happen, isn't the fact that the case is thrown out at half-time proof that there was no reasonable chance of this case being regarded as worth bringing?
I would say so. And it's not. It wasn't. Further than that, the magistrate's decision was not appealed. The prosecutor could have appealed and did not.
I'm surprised the civil courts of this country aren't flooded with claims for malicious prosecution, given the number of cases that are thrown out at half-time.
Well, my lord, in fairness, there are not that many which are thrown out at half-time. Okay. There are a lot of cases which result in acquittal. How many result in malicious prosecution claims? Very few. There are some. In fact, I was involved in one not long ago. But there are not many.
But by half-time, the prosecution's witnesses will all have been cross-examined.
They will.
And I mean, Lord Burroughs gave the example of a witness not coming up to proof, where he says one thing orally and quite different ones in his statement. But why can't a magistrate take the view that the cross-examination of a witness, although he apparently came up to proof in chief, was so effective that he concludes at that stage, look, this case, I just am not going to be able to place sufficient weight on the evidence of this witness to allow the case to go any further.
And that does happen. It happens in Crown Courts as well. It can happen with the view of an expert witness, for example, where having provided an expert report, the expert is then confronted with the defence expert. They have a conference, and the prosecution expert says, actually, I have doubts about my conclusion.
But even if he doesn't, the court may have sufficient doubts about his conclusion, having heard him being cross-examined, to think the case shouldn't go any further.
Exactly. So the fact that the case is dismissed at half-time is not absolutely...
No. How do we know that's not what happened here?
Yeah. Well, we don't, because the magistrate didn't give reasons.
So we can't really deduce anything, can we, from the fact that the case didn't go beyond half-time in front of the magistrates, except the point you made a few minutes ago, that we have a prosecution which failed.
Yes.
That's it doesn't really take us further than that.
No, that's the starting... I agree, that's the starting point.
Yes.
So you then have to look at the assessment of the evidence. And interestingly, of course...
Well, you mean the assessment by the prosecutor prior to the hearing?
Yes, quite.
I mean, you're not, as I understand it, therefore placing any weight on the fact that in this case, the case was thrown out at half-time, except to show that it was an unsuccessful prosecution.
I'm relying on it, as my Lord Burroughs has said, because it proves that the prosecution failed on its own terms.
Well, but you just said we don't know. We don't know why the magistrate threw it out. Therefore, we don't know whether it was as a result, for example, of the cross-examination of the prosecution witnesses.
Well, it could have. What I mean is, it failed on its own terms in the sense that it did not survive challenge. It didn't require evidence.
What does that tell us?
It doesn't require evidence to be called. Well, what it means is it then begs the question, it does beg the question, of to the extent to which the flaws in the prosecution case, which were sufficient to cause a magistrate to stop it at half-time, whether those flaws, whatever they were known and were apparent or should have been known to the prosecutor.
That's the issue. That is the issue, isn't it?
And we can't ask the magistrate.
No, we can't. So that is the real issue. We have to look at the evidence that the prosecutor gathered and what was before him, all the statements that were before him, and in the light of that, the decision maker, the trial judge, or whoever it is, has to conclude whether there was reasonable grounds.
And we can go straight to that, my lord, because that is precisely what the trial judge did.
I appreciate that.
And so that is why the fact of the submission, the successful submission, is the trigger for the action for malicious prosecution. It isn't a guarantee of success. It depends upon the trial judge's assessment of the prosecutor's knowledge at the point at which he charged, thereafter, up until the case.
Does anything happen in this case after the decision to charge and before the hearing, which you say rendered an up till then reasonable prosecution one without reasonable and proper cause? Or was it all there for the prosecutor to see when he made his decision to prosecute?
We say it's all there for him to see.
So we don't have to worry about the possibility of a perfectly good prosecution that goes bad before the hearing.
And that hasn't been subject of argument or submission either here
So,
or in the Court of Appeal. Or in the High
Interesting
Court.
legal question, but doesn't arise in this case.
It's purely academic.
Right, good.
I'm simply answering my Lord Borough's question.
No, I'm not criticising you for raising it. I'm just wanting to make sure that it matters.
I suppose I'm just trying to drive at. There is, I think, a submission on the other side that what happened at the Magistrates' Court, other than going to the fact that the person has been acquitted, is irrelevant.
Yes.
It doesn't matter whether the case proceeded beyond half-time or not. It's just an irrelevant factor when we're looking at the reasonable and probable cause element of the tort. I was really asking whether you accept that it's irrelevant or whether there is some weight that can be placed on that. I'm not saying it's conclusive, but can we place any weight at all in deciding whether there's reasonable and probable cause on the fact that the case did not get beyond half-time at the magistrate? I understand your answer to that, but we can place some weight on that.
We can. And then you look at the evidence before the magistrate, which is why the Court of Appeal's criticism and the Respondent's criticism of the judge for having regard to the evidence at the Magistrates' Court is misplaced. Because the judge assessed and looked at the evidence given before the Magistrates' Court, including the evidence available to Mr. Phillip, statements given by the witnesses who gave evidence and were cross-examined at the Magistrates' Court, in order to assess whether Mr. Phillip had reasonable and probable cause to expect the case to survive a submission of no case when he prosecuted it. And looking at the evidence that came before the Magistrates' Court, the judge was able to say that the evidence was flawed, fundamentally flawed.
I mean, clearly that's right, but the question is how was the prosecutor to foresee that? That, to my mind, is the question.
Well, the judge found, I would submit as a matter of fact, that he should have done.
Well, he says he should have investigated more. I don't think you've shown us anywhere where he says he should have appreciated that these witnesses would not survive cross-examination.
But his finding that there was malicious prosecution, implicit in that is that paragraph 35 means that he has found that there was no reasonable and probable cause.
No, I appreciate that, but what I'm trying to understand is where the judge says that the prosecutor should have anticipated that his witnesses would not survive cross-examination. Because, I mean, at the moment we don't know, and we will never know, why the magistrate threw it out at half-time. It may have been because he didn't think there was anything in the case, just reading the statements. It may be the witnesses didn't come up to proof. It may be that their credibility was sufficiently damaged in cross-examination. We know none of it. We simply don't know. So where does the judge say that having reviewed the evidence that was given orally at the hearing before the magistrate, the prosecutor should have realised that that would be the outcome?
Well, I submit that it follows from paragraph 35 and his ruling, his decision, that the prosecutor was liable for malicious prosecution. It must follow that at the moment when he instituted the proceedings, he had no just and reasonable cause for doing so.
You can say that what the judge is talking about isn't so much the evidence as it came out, but the evidence that the prosecutor came to present, which the judge may be saying that it didn't take cross-examination to demonstrate that the case he came to present was full of holes.
That's correct.
So presented at the...
Yes.
What does the judge mean by evidence that was presented at the magistrates' court? I mean, having gone through, as he has, the effect of the evidence as a whole, including the oral evidence, I should have thought that he was referring to the totality, including the oral evidence.
Exactly. Yes, he is.
Well, then it comes back to the question I asked.
Yes.
How was the prosecutor to know that his witnesses would not survive cross-examination?
Well, because it might not be that they didn't survive cross-examination. It might have been that even though they gave the evidence that they were expected to give, it was full of holes, and one of those holes was an element that's necessary in order to prosecute or convict someone of this offence. And
including whether you could conclude from you could possibly conclude from the evidence that Mr. Maharaj had anything to do with chopping down 35 trees.
If there was no evidence from any of the witnesses, even if they came out unscathed from the cross-examination, there was no evidence to link him with chopping down the trees, then that is something that Officer Phillip should have realised, because it was not something that depended on what was going to happen at the magistrates' court. Its case couldn't get any better at the magistrates' court than what he had.
So the focus, as my lady says, is really on what the case was before the witnesses gave oral evidence.
And the case was, in effect...
So we come back to the statements and so on, and what inquiries he should have made.
Yes. And so no direct evidence that he had anything to do with the chopping down of the trees. Nothing found like a chainsaw. In fact, the only chainsaw that was found was when Mr. Phillip interviewed Nareen, and Nareen produced a small chainsaw. Give me a moment. This is the electronic bundle, page 748. So this is pre-charge. On the following day, Tuesday, the 9th of September 2003, the said party, that's Mr. Phillip, revisited Ramesh Nareen to have a statement taken. After identifying ourselves, we informed him of our purpose of being there. Ramesh Nareen brought out a power saw from inside his house and said, "This small power saw cannot cut down them big trees." And he then opted to give a statement.
Oh, I see. This
is from Mervyn Atkinson.
This is Mr. Atkinson.
Mr. Atkinson.
And Atkinson, he was...
He's a forester, isn't
He's a police officer.
He's a police officer.
He is a forester.
He's a forester.
Wasn't he the one who was implicated in having instructed Mr. Jagannath to cut down the trees on behalf of some politician?
Minister, yes.
Are you going to pull together for us the key things that were relied on and those that ought to have come out on a proper investigation?
What, relied on by the prosecution?
Yes.
Yes, I am. In fact, I was about to do that now.
Okay, thank you.
But can I just, and that is the point of this reference, that one thing that was never discovered was any link between Mr. Maharaj and whatever it was that cut down the trees. Nothing found on his premises or anything to do with him, which indicated he had ever laid his hand on a chainsaw. 35 trees, combination of 10 cedar, 25 teak, we can infer must take some time and some effort to fell. No evidence anybody saw Mr. Maharaj do it. No evidence anybody saw Mr. Maharaj with any equipment to do it. No evidence of what happened to those trees immediately they were felled. The evidence was that Mr. Maharaj went to the forest reserve where there were felled trees, and he was then seen by Mr. by the forest officer, Mr. Jagannath. And he gave his explanation that he was there because he had had a report that somebody was stealing trees. And as a police officer, he went there to investigate. The evidence that was relied on by the prosecution was that there were...
So pausing there, he goes to the scene. It's been indicated to him that this is where the offence has been committed, is there? And he sees trees on the ground. There are stumps.
There are stumps.
And when there's a reference to logs, is that actually, do you understand, to the tree trunk as a whole, or has the trunk been, it's to the trunk?
Yes. So that's
and they're
where,
lying on the ground, so it looks like the scene of a crime.
it does. So there's a distinction between the stumps, which must have been visible,
Yes,
and whether they were all in one place or not, we don't know. It
Exactly,
doesn't
but anyway, right.
But there were stumps and there were logs.
Yes.
And there were fewer logs than there were stumps.
So he went there and he saw what he considered to be evidence of that crime
Evidence of a
having
crime.
been committed. Yes,
Yes.
all right. Yes.
And this was all in his statement.
It was, yes. The evidence relied on by the prosecution was that Mr. Fiddler, a neighbour of Mr. Maharaj, had seen him at some stage unloading some logs onto land over which it was said Mr. Maharaj exercised control.
Well, I think Mr. Maharaj accepts he owns that land.
No, his wife owns it.
I thought it was he and his wife.
He and his wife control it, yes.
Oh,
So, anyway, he exercised control over it, no doubt about that. 14 logs
Yes.
were found there,
Yes.
of which it was said 3 matched stumps in the forest.
Fiddler's evidence is that he saw this occur sometime between the 1st and the 4th of September.
It is.
Yeah. So, but just to say that's quite soon after, the logs have been found in the forest.
It is, yes.
Yes.
Yeah.
Okay. Yes.
So there is that link. And this is one of the reasons why I say that the High Court judge might have found in favour of the prosecutor.
But do you accept that 3 of the logs that were found in Ragunan and Trace did match stumps in the forest?
We accept that there was evidence that they did. The difficulty is that Jagannath's statement, his evidence, was that 8 logs matched the stumps.
8 logs from where?
From Raghunanath Trace, from the premises controlled by Mr. Maharaj. That was not the expert's evidence.
I hope you'll show us this evidence because I have found it quite confusing.
Yes.
In my, no, I don't want to take you out of your course, but just at some point.
I will. I'm afraid I was in 2 minds as the extent to which I needed to go into this detail of arithmetical.
I mean, I think this evidence is pretty important.
Yes, and had there been other evidence which supported it, the mere finding of 3 logs which categorically matched recently felled stumps in the forest, found on premises occupied and controlled by Mr. Maharaj, might, on its own, have been sufficient to give rise to a case to answer on its
And unloaded, and whose unloading was supervised by
if they were the same logs.
Mr. Maharaj.
Yes.
Well, yeah, if
Assuming they're the same logs.
yes.
The difficulty about that is that the evidence about the number of logs is very confusing.
Yeah.
Where they were found, how they got to where they were found, and why they got there. And how any of that gives rise to sufficient evidence to prosecute Mr. Maharaj, at the very least, for felling 35 trees.
Well, I mean, if the evidence was sufficient to give rise to a proper case that he had removed them or organised their removal onto his own land, your position becomes much more difficult, does it not, in contending that there was no basis for saying that he was involved in the felling of the trees in the first place?
It doesn't follow, friend. In the absence of anything else, you would have to say, well, how did he get hold of those trees and why? Is there any explanation? Because if there's an innocent explanation, then that gives colour to whether the mere fact of them appearing on his land has any weight sufficient to support a prosecution.
But did anybody check whether the tree logs which were found on Ragunan and Trace matched the stumps in Mr. Cedino's farm?
Matched the stumps?
Yes, wasn't it Mr. Maharaj's case that the logs that were on his land were ones that he had just bought from Mr. Cedino?
There doesn't seem to have been any investigation to that effect.
Well, yeah. I mean, Mr. Cedino gave a witness statement, was going to be one of the witnesses for the defence, as we see from page 603, but we don't know whether there was any matching that took place to verify or disprove that alternative explanation of what those logs on his land were.
My lady, what we do have is a matching report, which we have at electronic bundle page 745. And so
the concern I have, which I ought to express now, is that we're at risk of island hopping here, because we're looking at extracts of evidence here and there, and as I understand it, the case that's put against you is that all of this evidence as a whole does raise a sufficient case. It may be circumstantial, but it's evidence the judge didn't properly consider, or there is no evidence that he didn't consider it.
That's what's said, but in fact the judge did consider it. So the fact that it exists doesn't mean the judge didn't consider it. It exists, and the magistrate found it was insufficient for reasons we don't know. But the judge agreed with him and gave reasons why he said it was insufficient, because there were gaps in the evidence. And there was an absence of investigation of why those gaps existed and what further inquiries could be made in order to examine whether Mr. Maharaj's explanation and that of Mr. Sergeant Harridath were actually justified or not. Because it's in the same way as if a person gives an alibi which would provide a complete defence to a case, if the prosecutor simply ignored it, it would be difficult for a prosecutor in those circumstances to say that the decision to prosecute was objectively reasonable.
And what's the alibi analogy here? Sorry, as I understand it, you're accepting that 3 of the logs found on Mr. Maharaj's premises or premises he controlled were matched with the stumps from the forest that we're talking about. Now, you're then saying, but there is also evidence of an innocent explanation for that.
No, explanation for how the logs came to be there.
Yeah, which is what...
The question about matching is a different issue.
Yeah, okay, so what is it that is the equivalent of the alibi? What is the explanation? Is this something to do with, well, he was conducting a police investigation and taking the logs away in some capacity in that respect? Or is that nothing to do with it?
That seems to be one of the explanations, yes.
I think Lord Barrow's question is very much important. What is the alibi that is being put forward here?
What is being said is, insofar as there were any logs, Mr. Maharaj was conducting his task as a police officer to investigate a crime.
But he doesn't go so far as to say, does he, that he actually took logs away as part of that investigation, put them on his own land?
No, he doesn't.
So that isn't an explanation for the matching.
It is, and that's why I say this is material from which the High Court judge could have found that there had been a case to answer, but he had regard to all the evidence, including that, and decided in his capacity as a High Court judge that that piece of evidence was not enough to give rise to reasonable and probable cause to prosecute.
Yes, but was he right about that? And
Yes.
it seems to me that if you're caught with, one might say red-handed, with logs from trees that have been recently cut down without permission on your land or on land which you control, you're some way into being in hot water.
Well,
unless you have an explanation of how matching logs got there.
Can I give you an example of why it was open to the judge to have doubts about the strength and the efficacy of the matching evidence? If you turn
But hold on a minute. Why is doubts about the efficacy of the matching evidence enough to render the prosecution without reasonable or proper cause? There may be... You accept there is matching evidence, and there was matching evidence at the time of the decision to prosecute. Why does the fact that there may be some doubts about whether that evidence is going to hold up enough to make it with an improper prosecution?
Let me refer to what the Court of Appeal said about the matching evidence. It's in tab 8 of the core bundle, the Court of Appeal's decision, judgment, at record page 525. Can we start, please, at 524?
Yeah.
Roman numeral 7.
Yeah.
Jagannath in his statement said that in the course of the investigation he assisted other forest officers and Stephen Lee Moon, who was the expert, at the locations of the cut trees as well as the places where the logs are stored in order to facilitate the matching exercise. With respect to the initial 13 logs which were seized at Raganoon and Trace, that was 13 out of the 14, one you remember was left behind and was subsequently found burnt. They were taken to the forestry office in San Fernando. The single remaining log left behind, which was later discovered burnt, was eventually taken to the Cap de Ville nursery. Limoon in his report stated that the matching exercise related to the stumps seized from Main Ridge and the logs impounded at the forest office at Cap de Ville. He did not specifically refer to the logs seized from Raganoon and Trace, which were lodged at the forestry office in San Fernando. As, however, can be gleaned from Jagannath's statement and the report submitted by Lee Moon, it is apparent that the dimensions of 3 out of the total of 14 logs seized from Raganoon and Trace corresponded exactly to 3 of the positive findings in Lee Moon's report. The relevant matches are reflected in the table below, and the court set out that table. And I'll come back into the detail of this in a moment, if I may, but going on. To the extent that Jagannath represents at page 10 of his statement, which if you need a reference, it's the page 761 of the electronic bundle.
Sorry, which page again?
Page 761.
Yes.
To the extent that Jagannath represents at page 10 of his statement that there was a greater number of matches in respect to the log seized at Raganoon and Trace, this was a matter for the Tribunal of Fact to evaluate and resolve. Exactly. And that's what the High Court judge did. He regarded the match as reported of the 3 logs as insufficient to give rise itself, and in the absence of anything else, to reasonable and just cause.
Well, what they seem to be saying is that insofar as there are more than 3, then that's for the judge to resolve, but it doesn't diminish the potential probative significance of the 3 matches that were found. Isn't that how you read that?
Isn't the reference to the tribunal of fact there? I'm not sure whether it was a... You say that's a reference to the judge in this case, do you?
That's what I infer, my lord, yes.
I read that as a reference to the criminal court.
So did I.
Well,
To see how many, in relation to how many logs the charge was made good. And I thought the Court of Appeal was saying, well, he's banged to rights on 3, whether it's 3 or 8 would be a matter for the criminal court to decide.
well, I interpret it as being for the High Court judge to decide. It could apply to both. But whatever it was, it meant that the magistrate did not find there was a case to answer in respect to 3.
No, but it was for other reasons, presumably, that the case failed than matching problems.
Well, if
We don't know. There weren't
if the matching was sufficient,
Yeah.
the magistrate would have said there's a case to answer in respect to 3,
Okay.
and he did not.
Yeah, no, but come on, we've been over this territory. We don't know why the magistrate said there wasn't a case to answer in respect of the 3.
No, we don't.
So it's no use us saying the magistrate said there was no case to answer, because that's maybe, I thought you'd accepted this because of the way things panned out in front of the magistrate in a way which may well not have been foreseeable by the prosecutor.
But if this, irrespective of any other evidence, if this piece of evidence, as a freestanding piece of evidence, is sufficient in itself...
No one's suggesting in itself. We've got to look at all the evidence together. I mean, for example, Fiddler's evidence that he saw Mr. Maharaj unloading the 14 logs.
Yes.
I mean, plainly, that's very important evidence in this context.
But the question then remains, if there is not sufficient evidence to justify a case to answer on this evidence, then you have to say, why is it that the evidence is flawed? And is the judge completely wrong to say, as he did, that the evidence contained substantial flaws, which should have been resolved, might have been resolved by further investigation, rather than ignoring the problems that confronted the prosecution case? Obviously confronted the prosecution case, and Mr. Phillips shied away from them and didn't bother to investigate.
Well, maybe those are what you should focus our attention to, and what the prosecutor should have done, which would have outweighed in the balance this evidence and Fiddler's evidence.
Well, one easy answer to that is to say he should have realised that the evidence of Sergeant Harridath, insofar as it supported the claimant Mr. Maharaj's case, which the judge found it did in all material respects, was therefore likely to result in the prosecution failing.
And how does that evidence support the case of Mr. Maharaj in respect of at least these 3 logs? That's what I'm struggling with. What was Mr. Maharaj's counter-argument in relation to the three stumps?
The counter-argument is simply a submission that this evidence about the matching, based as it was principally on Jagannath's evidence, was unreliable.
No, it wasn't based on Jagannath's evidence.
It was, yes, it was.
Well, all that Mr. Officer Harridath talks about is that initial exchange between the men on the 30th of August and maybe the 4th of September. And that exchange doesn't seem to me to prove anything either way at the moment. But why, if you were going to show us 745, which I think includes as 10, 11 and 12, the 3 trees that were mentioned by the Court of Appeal in 524.
That's correct, my lady.
But, right, so that's not Mr. Jagannath's evidence, that's Mr. Lehman's evidence, right.
But his evidence is dependent upon Mr. Jagannath being accurate as to which logs came from which location?
Right, because the letter at the memorandum at page 744 says, seized from state forests in the main ridge and seized logs impounded at forest office that looks under the stamp as if it's Capdeville.
So by that stage, all the logs
Okay.
had been brought into a central location.
Okay, so there's nothing turns on the fact that it was San Fernando rather than
No.
Capdeville.
So it depends upon the accuracy of Jagannath in applying a number or a reference.
So that's the other parts of Jagannath's evidence.
Yes.
So Jagannath's evidence was that these logs 1, 2 and 4 had come from Mr. Maharaj's land opposite
Yes.
his house.
Yes.
And so you're saying, well, that was rather unreliable evidence.
Bearing in mind that he said that 8 matched. He said 8 of the logs found of the 14, 8 matched the stumps, which is not correct.
Right.
And that gives rise to the comment by the Court of Appeal that it was a matter for the Tribunal of Fact. In other words, this is not slam dunk evidence.
Right, so is this the situation that all the logs were taken to Capdeville, Stephen Lemoon looked at them and compared them with the stumps in the Forest Reserve and found some matches, but the only evidence as to where the ones that matched had been brought from was Mr. Jagannath's evidence that I think you pointed us to 761, where he lists 8 logs, including HP 16TLKJ or whatever, as having come from Ragnunan Trace.
Yes, it's 757, my lady. The electronic bundle is Jagannath's statement to that effect.
But that includes the 3.
That includes the 3, yes. Well, it includes the dimensions of the 3, yes.
7.
Sorry to go back to this, but and it may be that I'm just missing something, but you keep on talking about the evidence of Sergeant Hannah Regine Singe. That only relates to what was happening, doesn't it, on the 30th of August?
Yes.
So how can that actually have anything to do with this issue about the 3 logs, unless in some sense it's connected to some sort of idea that Mr. Maharaj was carrying out a police investigation, and that's why the 3 logs might have ended up on his land. But you say that's not part of the argument.
What it relates to, my lord, is the trial judge's assessment of the accuracy and honesty of Jagannath's evidence. Could he rely on what Jagannath said?
Sorry.
Could he rely?
Could he being
Jagannath.
could
So could the judge rely on what Jagannath said?
which judge
The trial judge.
in this case?
In this case.
But the real question is whether Philip could.
Well, and then deciding whether on his assessment of Jagannath's evidence and his character, whether it was reasonable for Mr. Philip to take at face value what Jagannath said, or whether he should have realised that Jagannath was a witness who was not reliable or credible.
So just give me a moment.
Right, so Jagannath's evidence is partly about what passed between them on the 30th of August and the 4th of September, and then there's a whole different part of his evidence about collecting up, numbering, stamping these logs.
correct.
which ones that Mr. Limoon examined had come from Raghanunan Trace. And you say that because the evidence of Officer Harry Prasad about what passed on the 30th of August was so directly opposed to what Mr. Jagannath says, it undermined Mr. Jagannath's credibility and should have made it clear to Officer Phillip that Jagannath's credibility was undermined to the extent that you couldn't really trust the other part of his evidence as to which logs came from where.
Yes. No, it doesn't.
One might go a bit further and say there's no evidence that he actually even confronted Jagannath with those issues. That Jagannath was never properly questioned by Phillips before instigating the prosecution.
Exactly.
Yeah.
And Phillips should have realised, because he had Jagannath's statement and he had the expert report of the moon, and Philip should have realised there's a discrepancy here. What's going on?
And he didn't, as I understand it, question Jagannath at all about those discrepancies.
He doesn't appear to have done.
Where was the evidence about the 3 logs rather than the 8 logs then?
The 3 logs, my lady, come in at page 745, Mr. Lee Moon's report. And what you have to do is you have to then link it to Mr. Jagannath's statement at page 757.
Yes. Now, but I think you told us that Mr. Jagannath was wrong to say that 8 of these logs matched relevant stumps. But where does he say that?
Give me a moment. I think it's at page 761. Yes, 761 and 763.
Okay, hold on.
761 is Mr. Jagannath, is it?
Sorry, I have to let me give you a moment to get the record.
Yeah, that's Mr. Atkins.
Well, it's
So with Mr. Phillip,
Where are you?
Mr. Phillip then fixed his markings along with my markings on the following teak and cedar logs along with their respective cookies, which match.
Sorry, what are cookies?
As I understand it, that's from the matching stumps.
Stumps, I see.
It's a disc cut from the top of the stump.
Thank you.
So you can take it away with you.
I'm with
So
it.
the idea is that
Yes.
there's a match of the diameter
Yes.
and also of the rings.
Okay.
Now, there may be certain circumstances in which they're identical between 2 trees in the forest, but that doesn't matter. What matters here is that he is saying that in the presence of Mr. Phillip, he, Raghanuth, identified that there were 8 matches. Mr. Phillip had access and received Mr. Lee Moon's expert report saying there were 3 matches.
But where do we see the 8 matches?
and well, it's
Oh, there.
it's the
I
table
see.
on
I see,
761.
Yes, yes. Teak log seized at Dragoon trace length by
Right, so that's those, he says those 8 are the ones that were seized at Ragunan and Trace,
Yes.
right? Those are all logs, and those were marked with his marking and with Officer Phillips' marking. And then you can match those, all those 8 matched onto the table at 745.
It's the HB16TLKJ reference.
Yes, those are at 745. They're numbers 10, 11 and 12.
Yes.
But what about the other 5? Or maybe they are, but they're not confirmed as a match.
If you look in the last column, there's
Yeah.
the additional logs which match the same cookie.
Which page is that?
The last column on page 745.
And
745.
Additional 745.
I'm sorry, I'd be grateful if you could, if this is an important table, if you'd be kind of just to talk me through it, because I can see that 1, 2, 3. There may be an indication here of more matches.
What are the columns?
Well, you can see those on 745.
Yes.
Are you able to assist us as to how this table works?
Only on the face of what it says.
Right, fair enough.
I mean, there are several questions begged by this. You know what my learned friend says about, oh, well, if you add the logs up, then you end up with 8 altogether. But
we're not going to decide, obviously, any question about the 8. I think the point you accept that there are 3 which match, and you accept that that is evidence which could have, that the High Court judge could have properly found that there was a reasonable case for the prosecutor to bring, but he didn't find it, having looked at all the evidence, and he was the decision maker. That's the point, and the Court of Appeal had no business interfering. Now, so far as the prosecutor, Mr. Maharaj, rather, was concerned, or the prosecutor was concerned, I think you were saying that this was all a bit unreliable because of Jagannath's identification of 8 as being from Mr. Maharaj's land. Was that the point you were making?
It was. I was taking the Court of Appeal's statement at face value.
Yes, and that's something that showed Mr. Jagannath's evidence was unreliable, you're saying.
It was capable of doing that. I'm not saying categorically...
And are you saying the prosecutor should therefore have followed it up in some way?
Yeah, exactly.
Right. And he should have followed up. Yeah. I mean,
I'm not saying that the only conclusion the judge could have come to was that Jagannath was lying and that these matches were completely unreliable. What I'm saying is it was a conclusion he was entitled to reach.
Yeah.
After all, it's not me who's seeking to subvert the judge's decision.
But all this evidence of Mr. Leemoon and those statements from Mr. Jagannath about which logs came from where, that was all evidence that was in front of Officer Phillip at the point that he made the decision to prosecute.
Yes.
What it seems to come to is this, that if the Court of Appeal was entitled to interfere with the judge's decision, so that it fell to the Court of Appeal to make the judgment as to whether there was reasonable grounds for prosecution, then they had a proper basis for making that judgment. And I think it follows from what you've said to us. So the real issue is whether the Court of Appeal was entitled to interfere with the judgment below. I mean, if they made some significant error, if the judge below made some significant error such that the Court of Appeal was entitled to interfere with the judge's decision, then it became their decision. So that's the key, isn't it? What, did the judge at first instance, in the way he approached the issue, make a sufficient error that the Court of Appeal was right to interfere? That's really the issue on this appeal, isn't it?
Had the ruling been the other way,
Yes.
Mr. Maharaj would have had no ground of appeal.
Yes, I follow that. And equally, if the Court of Appeal was right to interfere so that it became their decision, then this appeal must fail.
I would agree with that.
Yes, okay, well, that's very helpful.
Could I mention, before I go on to the Court of Appeal's reasons for intervening and the extent to which those reasons satisfied the legal test for when a Court of Appeal can interfere? Just one other issue about the arithmetic of the number of logs. According to the agreed statement of facts and issues, at page 967. Paragraphs G and H and I. Subject to the point in Mr. Leemanoon's report about how many logs were comprised within one particular exhibit, the position seems
These aren't agreed facts, are they? This is the prosecution.
These are agreed facts.
Well, paragraph 7 starts as, prosecution case can be summarised as follows.
Yes.
And this is all the prosecution's case, not the agreed underlying facts, is it?
No, well, this is the prosecution case, as agreed, part of the summarised facts.
It's agreed that this is the prosecution case.
I'm so sorry, my lord. Yes, it's agreed this is the prosecution case.
Right.
So not agreed as this is definitely the truth. So the arithmetic is this. 35 stumps were found, of which 10 were cedar and 25 were teak.
Yeah.
So on the face of it, the prosecution cases, those are the trees that were felled. 35, 10 cedar, 25 teak.
Where were they found? Or they were just, those were the ones that were all gathered at the...
12 were found in the forest, remaining in the forest. Although in paragraph G, the final sentence, for some reason it said that 13 were removed. That must be an error. So 12 in the forest, 14 teak at Raganoon and Trace.
I'm sorry, I'm getting quite lost. You took us to page 967.
My lord, yes.
But you're bringing up new numbers. So
I am. I'm afraid this is my computation.
Oh, okay. So what are we...
I've added together 35 felled trees in G, 10 cedar, 25 teak.
Mm-hmm. Yes.
23 of the trees had been removed. Remaining 13, it should be 12, were subsequently removed. So 13 had disappeared.
I see. Yes, sorry, yes.
So 23 of the trees had disappeared, 3 cedar and 20 teak. Remaining 12/13 were seized by Mr. Jugganoff. Went to Raganoon and Trace. There they seized 14 logs.
Right.
So the 12 to 13 were seized by Jaggernaught in the forest?
In the forest. They had not been removed by whoever felled them. So 14 logs at Raganoon and Trace. And then I, a depot in Barrackpore, which is evidentially a complete mystery. No evidence it has anything whatsoever to do with Mr. Maharaj. 20 teak logs were seized from there. So in summary, 35 stumps in the forest, of which 10 cedar and 25 teak. Found and seized in the forest 7 cedar, 5 teak. Raganoon and Trace 14 teak. Barrackpore 20 teak, which equals 46 logs.
I'm sorry, I didn't.
So that's more than the stumps.
Yes.
So some of them must have come from somewhere else.
Yes. And no investigation. I mean, some of the Barrackpore logs appear to be to a match, but no investigation appears to have taken place by Mr. Phillip about who at Barrackpore was responsible for either felling or removing or receiving those logs. Or whether, as the judge criticised him for, whether it had anything to do with the allegation being made against Mr. Jagannath.
Well, Mr. Carter, I think we probably need to move on from numbers.
I think we do.
Logs, because you've only got 22 minutes left.
Yes.
I realise we've been asking you a barrage of questions and you've been very helpfully replying, but we'd better give you your remaining time to focus on the errors, the alleged errors made by the
Please.
judge and why they weren't enough to enable the Court of Appeal to intervene.
I'm so relieved to get away from logs. Now, the test for whether the Court of Appeal can intervene is plainly wrong. I suspect I don't need to give you chapter and verse about this. Can I just give you the references to the authorities?
Yeah.
I'll take you to them if you want. The first one is the authorities tab 2, Beacon Insurance and Maharaj Bookstore at pages 1044 to 1045.
Yes.
I'm going to mispronounce this, I suspect. Azikurath Zioni and Arab Insurance, tab 10, at page 1200. The dictum of Lord Justice Ward. And then a new case that was submitted recently, Juman and the Attorney General, tab 28. Paragraphs 13 to 14.
Page.
Page.
Sorry, I'll... '52 and 53, my lord.
This is of a supplemental bundle,
It is,
is it?
yes.
Yeah.
There is one case in the supplemental bundle which I apologise for. I have no idea why it's there.
I can't explain it either.
One of you was trying to put off the other.
Anyway, thank you. I don't think we need to take time over.
No, and the...
We have to apply it almost daily.
I know, because it's been so... I'm afraid something... Due to the length of time it takes for cases to go through the appeal process in certain jurisdictions, I'm afraid your efforts to try and explain the principles of when appellate courts intervene have still not worked their way down properly yet. But so I hope you have patience with the fact that we're dealing with something which you've said time and time again and explained time and time again. And you're familiar, obviously you're familiar with the reasons why appellate courts have to be cautious.
Yeah.
They're set out in Henderson and Foxworth Investments at page 1104 to 5. Beacon Insurance against Maharaj Bookstore at pages 1045 to 1048. The recent Water Sewerage Authority case at tab 27, pages 1645 to 47. And Stewart and the Attorney General, tab 26, at pages 1628, paragraph 14. 1629, paragraph 15, through to 1631, paragraph 17, and 1634 to 1637, paragraphs 23 to 24. The starting point for this submission, bearing in mind what those tests are, and the obligation of the Court of Appeal to intervene only when it is proper to do so, and not simply because it prefers its own version of the events or the inferences to be drawn from the events to that of the trial judge, is that it's significant, I submit, that nowhere in the Court of Appeal judgment does the court refer to the trial judge's assessment of the credibility of the prosecutor himself and of the witnesses. And it was his assessment of the credibility of those witnesses which gave rise to the judgment he made. Can I give you the specific references? His comments and conclusions about the witness Juggernaut are at electronic page 357. Of Mr. Philip.
Paragraph, sorry.
Oh.
26.
Yep.
26, thank you.
At Mr. Philip at 358 to 359.
So this is at the end of para 31. He hadn't, yes, I see.
Hari Prasad, pages 352 and 354. Sorry, my lord, my screen keeps dying on me.
Okay. Yeah. Where is that?
And of Mr. Maharaj himself, briefly, at 352.
What was the Hari Prasad references? Sorry.
352 and 354, my lord.
Thank you.
And I would submit that ignoring that fundamental role of the High Court judge, that fundamental process by which a High Court judge reaches conclusions of fact, is a significant flaw in the Court of Appeal's approach to addressing whether it was entitled to overturn the High Court judge's decision. It's interesting that in the respondent's case, at paragraph 42, page 1003, the respondent claims that the judge placed too much emphasis on his assessment of the witnesses he saw and heard. That, in my submission, is not a criticism, that can be sustained. It is the judge's function to do precisely that. Only when he errs in some very grave or material way can the Court of Appeal intervene, or where the judge, in translating findings of fact into conclusions of law, if he errs there, then the Court of Appeal has a role. But in my submission, he did not err in law. Can I deal briefly, and I know I'm short of time, but I'd like to deal with the material errors which the Court of Appeal identified. They identified 4. And the first material error appears in the Court of Appeal's judgment, tab 8, page 526.
Paragraph?
Starting at paragraph 49. And it is said, first line, second sentence, the first is that he failed to appreciate the collective significance of the circumstantial information identified at paragraph 47 above, which is the specifically those aspects of the case which the prosecution relied upon. This information, when viewed with the requisite caution, but also cumulatively, the Court of Appeal said, was capable of supporting the conclusion that ASAP Philip had an honest belief in the guilt of the respondent, and so on. Was capable of. That is not the test. Paragraph 50. Put another way, the conjoint effect of this material was capable of supporting on one possible reasonable view, not the test.
What do you say is the tests that they're applying, and what do you say the test should be then?
They're applying a test which would be suitable if they're considering an appeal against conviction in a criminal case. If there are 2 reasonable alternatives and the trial judge reaches one rather than the other, then that is what the trial judge's function is. And it is not susceptible to appeal unless there is a real identifiable error in the trial judge reaching one rather than the other. So when the courts say there is an alternative reasonable error, what it means is the judge has chosen one of 2 possibles.
Now, I'm not sure that's quite the way I read this. 49, they first of all say he's made 4 material errors. In the next sentence, they specify the first, having identified that as an error, they then apply their view to the evidence as a whole, rather than looked at in silos. But the criticism that's made is that the judge didn't look across the piece, he just looked at the evidence in silos. So, in other words, the third sentence of 49 is not a criticism of the judge, it is their conclusion, having said the judge approached the issue wrongly.
But even then, what they say is, was capable of supporting, not must have supported.
Well, no, but capable of supporting would be enough to have reasonable grounds. But that's their decision. What they're saying is he hasn't looked at the evidence as a whole. He's looked at it in silos. We have looked at it as a whole. We say it is capable of supporting.
And it's therefore, interestingly and inconsistent, that their next...
But I think you're reading it differently. You're reading it was capable of supporting in the mind of Judge Seepersad the conclusion that Officer Philip had an honest belief. But what they may be saying is, looking at it as a whole, it was capable of supporting in the mind of Officer Philip the conclusion, an honest belief in the guilt of the respondent. Isn't that what they're addressing?
They may be saying that, but even so, unless they can say that the judge, had he applied the right test, must have reached that conclusion,
No.
that it was reasonable.
No, but the criticism is that he, I mean, you may say it's an unfair, I think you need to look at, I mean, was this a fair criticism to say that he looked at the evidence in silos rather than looking at it as a whole? That seems to me to be where your focus needs to be.
Well, in that case, my lord, then let me say that this criticism is undermined by their next material error that they understand, that they identify, which is that the learned judge relied on the evidence or referred to the evidence of the magistrates' court.
So this is in paragraph
54.
54.
Yeah.
So, yes, page 528, paragraph 54. So, on the one hand, they're saying he didn't refer to all the evidence. But on the other hand, they then criticise him for referring to...
No, sorry, forgive me. Go on.
Referring to the evidence.
Yeah, but this is the evidence before. They're saying that they shouldn't be looking at the evidence that was given orally before the magistrate. Because what they're saying here, the judge made reference to the evidence given by Denou before the magistrate and how it conflicted with what was contained in his first statement.
Yes. But what it means is that the learned judge was having regard to all the evidence, but the test he applied, which he did correctly, I submit, was to use the evidence, as I started off, a bit like T.S. Eliot, in my end is my beginning. We started off by he looked at the evidence that was given at the magistrates' court and then considered whether the fallout from that evidence was something that Mr. Phillip should have anticipated. So that's why he was looking at the evidence of the magistrates' court. Was this something that a reasonable and diligent prosecutor would have anticipated to have happened?
Yes, but did he ever say that? I'm sorry to be taking up time, but I mean, the judge made reference to the evidence given by Denou before the magistrate and how it conflicted with what was contained in his first statement. But did the judge ever find that Philip should have anticipated that Denou's oral evidence would conflict with his own statement?
Paragraph 18 of tab 6, page 354.
Thank you.
Paragraph 18. Prior to the institution of the charges against the claimant, the complainant had before, Mr. Phillip had before him the statements of Mr. Maharaj, Denou and Officer Harridath, which were all submitted to the Senior Superintendent Alfonso. There is no evidence before this court to suggest that Mr. Phillip ever questioned Denou about the contents of his statement.
So Officer Phillip had before him, at the point that he made the decision to prosecute, both Denou's statement made on the 11th of September, which was supportive of Mr. Maharaj, and also his different witness statement.
Yes.
So it's not just that he gave the evidence, the oral evidence he gave the magistrates came as a great surprise to everyone because it was different. It was the same as his earlier statement, and therefore there were two, as Officer Phillip knew, there were two conflicting statements
Yes, when you're a reasonable prosecutor, when you have inconsistent witnesses, statements by a potentially important witness, you don't simply cross your fingers and hope that the witness will come out with the one version you hope that's going to support your case. You make inquiries.
And those are inquiries of Deneau himself.
Yes. And the judge's assessment of that, and it was a rolled-up assessment, which he's entitled to make, was at paragraph 31 of his judgment at page 358. Six lines from the bottom of that paragraph, the middle of the line, before this court. Before this court, Mr. Phillip did not materially depart from his evidence as contained in his witness statement. However, he did not engender in the court the feeling that he left no stone uncovered during the investigative process, and the court was not impressed by his responses and felt that he deliberately gave very generalised responses in relation to some of the questions posed to him in cross-examination. Questions which we submit Mr. Phillip should have asked. One of the criticisms made of the trial judge is by the respondent. In their case, at page 999, paragraph 25, it's accepted that there was no direct evidence to link Mr. Maharaj with the felling of the trees. It's accepted that there was, by the prosecution, that there was no direct evidence, and the judge is criticised apparently for saying that there was no direct evidence. But in fact, his reference to there being no direct evidence is but one of several reasons that he gave for reaching the judgment that he did. And that is at page 360. Paragraph 32G. And it may be of significance, it may not, but it may be of significance that is the final reason he gives for concluding that Mr. Phillip had no reasonable and proper ground, rather than being the first. So the criticism that he was unduly influenced by the absence of direct evidence, in my submission, falls on the ground.
But that was only one of the charges. The other one was removal.
Yes. But if you've got no direct evidence of felling, which is the starting point, well, I'm not going to go into the evidence again, but it begs the question of who did it, who did the felling, who did the removing, how did the logs get to where they were. So there was a bit of investigation about that, and that explains the statement of Fiddler, and we've been through that. But there are still many gaps that were left, I would submit. So
that's the second of the errors the Court of Appeal identifies.
And the third, page 530, paragraphs 57 to 59, is the judge's finding that there were glaring gaps and deficiencies in the evidence. That's a reference to the judge's comment at page 360, paragraph 35, 8 lines up.
We've been there.
We've been there already. I'm not going to repeat that. So he identified what those were. So And here we come back to the judge's role in criticising Philip as a witness. The Court of Appeal did not have Philip in front of them. They did not see him, they did not hear him. And the authorities show that the capacity of a judge, or the role of a judge, the function of a judge, is to use that opportunity, that privilege, in order to reach material findings of fact.
And the material finding relevant to the cause of action here is what?
Is that Mr. Jagannath was, when asked questions...
Oh, Mr. Philip, I thought you were referring.
Sorry, when Mr. Philip was asked questions about why he did not do this, why he did not do that, he was evasive.
Gave generalised answers.
Generalised answers.
And left stones unturned.
Exactly.
So it was a sort of finding, would you say, about the quality of his investigation?
Well, exactly.
What is the finding that the judge made based on his impression of Philip as a witness?
That he was a witness who had not bothered to do a proper investigation, so as to satisfy himself there was a proper case fit to be left to a court.
The last sentence of paragraph 31, as I understand your submission, maybe said to embrace a finding that he was deliberately giving generalised responses rather than engaging with the details that were put to him.
Yeah. And we have evidence, in fact, and this is why the judge was entitled to rely upon evidence at the magistrate's court, because what Mr. Phillips said at the magistrate's court in the bundle at page 665 and the judge was entitled to rely upon this as Mr. Phillips' evidence of his approach to the investigation and prosecution.
Is it page 6?
665.
665.
I'm very concerned
7 or 8
about
lines
time.
down, I addressed him. So the 4th line down at the end, I addressed him as Harridath Maharaj when I spoke to him. I knew he was a police inspector. He said off the record that Jagannath should be locked up and that it have ministers involved. I did not ask him who were the ministers. Jagannath is a witness. He is one of the witness. I don't know what does a main witness mean. I was not interested why Maharaj saying that my witness should be locked up. I was not interested in finding out who the ministers involved might have been. When I interviewed Maharaj, he promised to supply me with a statement when we visited the scene at Raganoon and Trace. I cannot say from the statement that he refused to give a statement. No need to refresh my memory. He said that he would not give a statement at that time but would supply one later. It's the I was not interested. That was his evidence that the judge was entitled to rely upon as part of the comprehensive picture of the evidence in the case.
Well, we're coming very much to the end of your time. Carter, what's the final... There were 4 errors you would take us to.
And the 4th error I can deal with very quickly because the judge has relied upon submission made by counsel for Mr. Maharaj that the prosecution had to prove that there was no licence. That is wrong in law.
Oh, the reverse burden of proof point.
Yes, Court of Appeal was right on that.
And the judge did rely on it.
The judge did rely on it, but it wasn't there were other grounds as well. So had that been...
You accept the criticism, but you say it is swept away by these other...
Yeah, I do. Yeah.
Right, thank you. Well, I think unless there's something...
Oh, sorry, one final point. Mr. Nareem. The Court of Appeal agreed that Mr. Nareem's evidence, insofar as it was, his statements, were inadmissible, could never have been evidence at the court.
Against
Mr. Maharaj.
Correct, yes.
It's interesting that at the moment, the respondent still maintains that Mr. Nareem's statement.
Well, he says it was still relevant
It was.
to honest belief, even if it was inadmissible.
It showed he was on the right track, is how it's put. But that is not the test. It was wrong. It is not something he could have relied upon.
No, but the point that's being made, I think, is a different point, which is that it's in response to your point that he should have done further investigations, for example, into the allegations that ministers were involved. He says, well, I had material, not evidence, but material, which pointed to Mr. Maharaj being the perpetrator. That's the way it's used.
And you look at the source and say, as an investigator, well, is that enough? It's a simple point. It wasn't evidence which satisfies the test of would this case survive no case to answer submission. Because if you're having to rely upon something which is an out-of-court confession by a co-accused, it's not evidence, you cannot rely upon it. Yes, you can use it, for example, as a basis for reasonable suspicion to arrest, but not as saying this is evidence upon which I can say there are reasonable grounds, reasonable probable grounds for saying a court will say this is fit to be tried. So, can I end on that point?
Thank you very much. Yes, Mrs. Frank.
Well, if I may, I'll start with the threshold for appellate intervention, because I take a different position from my learned friend. The threshold depends on the judge's task. On the judge's task. So the threshold for appellate intervention depends on the judge's task.
Yeah.
And on the question of the absence of reasonable and probable cause, the judge had two questions before him. One was the objective question: did, shall we call him Philip, have reasonable grounds for believing that there was a proper case to lay before the court? And the second was the subjective question: did he honestly believe that there was a proper case to lay before the court? And as we've seen in this case, the focus was almost entirely on the objective question, because the judge answered the subjective question of honest belief by answering the objective question. He said, and this is at page 360, based on the evidence, you've seen this, my lords and my lady, based on the evidence that was presented at the magistrate's court, it simply cannot be said that the complainant could have formed an honest belief. So the subjective question was answered by the objective question. And in answering the objective question, the judge had two tasks. First was to establish what material was before Assistant Superintendent Philip. Now, in some cases, that can involve a fact-finding exercise, but not in this case, I say, because it wasn't in dispute what the various witnesses had said to the Assistant Superintendent. It was all recorded in the statements he took from them. And allegations of concocting evidence or of putting Narayan under duress were not pursued. The second task, to decide whether the appellant was right to say that the material could not amount to reasonable and probable cause.
When you say those allegations weren't pursued, you mean in the course of this civil litigation before the malicious prosecution?
Yes. So the pleaded case was that evidence had been fabricated, concocted, Narayan had been put under duress. None of that was pursued in evidence or in cross-examination. So there's no dispute over what the witnesses said to Superintendent Philip. It's all recorded in the statements he took and in the report of Mr. Lee Moon. So the only question was whether the appellant was right to say that that could not amount to reasonable and probable cause. And as the authorities say, that second question is a purely objective question.
So we put to one side entirely on your submission the arguments, the pleaded case to that extent.
Yes. Fabrication, concoction, duress, we have to put that to one side, yes.
And where do we put in this equation the submission we've heard about Mr. Phillips, Inspector Phillips' failure properly to engage with the questions put to him?
Well, yes, in terms of whether he should have investigated, whether that's still an objective question, whether on the material he had before him there were obvious lines of inquiry to follow, and that a case would be defective without doing so. It's still an objective question.
Because if there is reasonable and probable cause, then however malicious Philip was, or however poorly he investigated it, the claim for malicious prosecution must fail, is that?
Yes, that's right, my lady, yes.
But here, there's no independent allegation of malice, is there? That's the
Well,
point
there was,
you're
but
making.
again, that wasn't...
There was, but not
the
pursued.
superintendent.
Right, right.
We'll get to malice because the judge's, the way he approached malice was wrong in law.
I see. Right, I see.
But going back to the objective question and the appellate threshold, it's always described as a purely objective question in the authorities. Sometimes it's described as a question of law, sometimes it's described as a question of fact to be treated in the same way as a question of law. It's always described as a question for the judge and not the jury. So we can see that at, for example, the case of Meering, which begins at page 1478, so 1479, and I'm going to go through in the judgment of Lord Justice Warrington to page 1488. One, two, three, four, 5 paragraphs down there. The one that begins, for the purpose of establishing his case. So moving on from malice to the question of a lack of reasonable and probable cause, that was a question partly for the jury and partly for the learned judge. For the jury, so far as there were any facts in dispute, we covered that, and for the learned judge, whether, when those facts were found, they constituted in law an absence of reasonable and probable cause.
But it's fair to describe it as a sort of multifactorial question of fact and law, isn't it? Once it's all being done by the judge and you don't have a jury anymore.
Well, there are jury questions to be decided by the judge, and then there is one objective assessment. Once you've established what all the facts were, as known to Superintendent Phillip, you will then have an objective question. Is that a case to put to a court?
So that's an evaluative exercise, you would say?
It's yes, but it's not an evaluation of facts.
No, I follow that. It's not a fact-finding exercise. The facts have been found, or as you would say in this case, there was no dispute about the facts.
But it's if we use the distinction of judge and jury, it's a purely judge question.
Follow.
In Glinsky, it was described. So Glinsky is page 1372.
Or 1832.
1372.
Oh, sorry, I misheard you.
And at page 1388, Viscount Simmons. Starting in the middle of the page. My lord, such difficulty as there is. This is as to want of reasonable probable cause, arises from the fact that It is for the judge to determine, whether as fact or law, whether there was such want, whereas it's for the jury to determine any disputed facts which are relevant to that determination. In other words, what was known to the prosecutor. And going on down, there's a reference again to the test being purely objective, and then I'll just take your lordships and your ladyship to the last sentence on the page. The judge, equipped with the information which at the relevant date the prosecutor had, has to decide, adopting the standard of the reasonable man, whether there's reasonable and probable cause. And
this is the sort of classic evaluative exercise that courts have to engage in all the time once
yes.
the facts are known.
Yes, but it's an exercise to which there's only one right answer, or at least there shouldn't be much room for disagreement on it.
Right, so I'm struggling slightly here because you're not going. You're going behind what the Court of Appeal themselves have seen their task as being. Are you?
Well, I'm going to go. No, my Lord, I'm going to take you to their judgment and say.
Well, if I can take you to paragraph 48 on page 526, they start off with the application of the Beacon Insurance Company test. Now, as I understand the submission you've just made, we're not in Beacon Insurance territory.
Well, we can be, because the Court of Appeal still has to find that the judge was wrong, but it's the area in which the judge can disagree from the Court of Appeal is that much narrower.
Well, yes. So paragraph 48, the Court of Appeal effectively is saying we're applying a plainly wrong test, and then they go on to give the 4 material errors that they regard as applicable. But as I understand your submission, that is not what we should be doing. We shouldn't be applying a plainly wrong test. We should be applying a wrong test.
That is my submission, yes.
Okay, so you are going behind what the Court of Appeal have said.
Yes, well, when it comes to evaluative exercises, I think the appellate courts will nowadays say on an evaluative exercise the use of the qualifier plainly might be misleading.
But that's a separate point.
Wrong is enough.
This is your submission. That
Wrong's enough.
This is an evaluative exercise to which the appeal courts apply a particular approach, and you're going to take us to what that
Yes.
approach is.
I was going to take your lordships and your ladyship to one more passage from Glinsky, which is in the judgment of Lord Devlin at page 1414. It's the second paragraph. 6 points are settled about the question of reasonable and probable cause. Thirdly, though a question of fact, it's one that in the end has to be determined by the judge, and so is to be treated in the same way as if it were a question of law.
It's dangerous. He's here talking about judge or jury again, isn't he?
Yes.
It's dangerous simply to transfer from in a jury trial, is this a question for the judge or the jury, as if it's applicable across the board to the extent of the Court of Appeal's power to intervene against findings of a trial judge.
Yes, I accept that, my lord. But I'm here looking at the second element of the question. As I said, there are 2 tasks. First, to establish, as a matter of fact, what was before superintendent.
Yeah.
Secondly, to establish, on a purely objective question, did that or did it not amount to reasonable probable cause to prosecute?
But as I understand your submission too, you're not simply saying the evaluation was wrong. Your submission is that it's appropriate for an appeal court to see if there's an error in the evaluative process. So if they fail to take something into account...
Well, I say both. I say that the Court of Appeal is entitled to say, as it did, this evidence, these deficiencies were not capable of amounting to an absence of reasonable probable cause. That which, in other words, that's an assessment that the judge got the objective assessment wrong. They said that. And then they also identify, and I identify, errors in the evaluative exercise as well. So I say both.
And either is sufficient to interfere on your submission.
Yes, my lord.
And as I understand it here, you'd point to the last sentence in the Beacon quotation at paragraph 48, that in relation to at least one of the ways you're putting it, the court is required to identify a mistake in the evaluation that is sufficiently material to undermine his conclusions.
Yes. Yes, I do that, and I say the Court of Appeal correctly did that. But I also say, while we're on Beacon, we are at...
But isn't that relating to findings of fact?
Yes.
I mean, this business of evaluative exercises, I mean, there's quite a lot of authority on the approach to be adopted by an appellate court, and it's not actually that different to interfering with an exercise of discretion. I mean, you ask, first of all, did the court take account of an irrelevant factor or an inappropriate factor, or the other way around, failed to take account of appropriate factors? If the answer to both those questions is that the judge looked at the correct factors and didn't exclude anything, then was his evaluation one he could reasonably come to? And if it was...
Or is there no reasonable judge test?
But it's not. The Court of Appeal might evaluate it differently. It goes further.
In that case, I don't agree that that's the test
Right, well,
here.
in that
This
case,
is a purely objective question.
Yeah, well,
Whether these facts make a prima facie case, if believed, do they make a prima facie case against Inspector Maharaj?
Do you agree that it's an evaluative exercise?
Well,
Which it must be. I mean, even though there's only
yes.
one correct answer, nonetheless it's evaluative, and it's for the judge. The judge is the decision maker,
Well,
not the Court of Appeal.
it's evaluative, but not in the sense that it can be treated like an exercise of discretion.
Well, I'm not saying it is, but actually, my recollection is when you look at the authorities, there's quite a parallel between them.
But,
Although it's not an exercise of discretion.
Well,
There are authorities, and maybe you'll take us to one or two of them.
I have one in mind which I don't have before us, but if we're talking about the difference between evaluative exercise and discretion, there's a more recent authority from the Supreme Court saying that evaluative exercises are not always like an exercise of
what we're
discretion,
really
and
interested in is
that's
what
where
the
you use
test
the
is.
wrong, not plainly wrong, maybe misleading.
What I think the question is, what is the test?
Yeah.
But, sorry.
I mean, isn't there ultimately a bit of a spectrum? I'm sorry if that sounds very fuzzy, but with at one end, pure questions of statutory or contractual construction, in which case the Supreme Court's just as good as the trial judge and does it all over again. And distressingly for judges, doesn't often make much reference to the analysis in the courts below. Then at the extreme other end, probably vying for first place, findings of primary fact and possibly the exercise of discretion, because that is conferred on a judge, and then an evaluative part of the spectrum in between, where what the judge is having to do is a mixture of fact-finding and evaluation. And it's not always possible to say, well, you do the fact-finding first and then evaluation. You often have to go back and, you just have to do the whole
That's
job.
right in this case, my lord. I think the fact-finding is separate from the evaluation.
So here you say the fact-finding is what actually was the evidence before Officer Phillip. So there's no dispute about that. We know what he had in front of him. But the question as to whether that was objectively, whether that gave rise to reasonable and probable cause, is, you say, not any kind of protected decision on the part of the judge. The judge makes his decision. You can appeal against that. The Court of Appeal would have arrived at a different view, then they change the result. That's your... But then your fallback is, well, if it is evaluative, then there were errors here that entitled them.
Can I suggest to you that when you're in this, and I agree with what Lord Briggs has said, there is a spectrum. Now, you're wanting to tell us that cases like whether reasonable care was exercised or something of that kind are always questions of law with the right answer. You're saying, well, objective tests. And I think it may be that the approach that the courts are taking is, within that spectrum, it does depend on whether you think the trial judge has got a real advantage in relation to the exercise that they're carrying out as against an appellate court.
Yes.
Now, here, it might be said against you that the judge here does have a clear advantage because he has at least seen and heard these particular witnesses, and therefore you can't really just push this out to being a pure question of law.
Yes, that point's taken against me, and I say that advantage is minimal, or even, I wouldn't go so far as to say specious, but the judge didn't say, by the way, that having heard Harriprasad and having heard Jaggernaut, I was so convinced that Harriprasad was such a credible witness, and Jaggernaut was so obviously incapable of belief that Philip should have made the same assessment. He doesn't say that. What his findings about what Jaggernaut says to him, or what Harriprasad or the claimant said to him, make no difference to the facts as they were before Superintendent Philip, on my case.
This goes back to the separate argument that, as I understood your submission in written form, it was that it is irrelevant to think about that question, and that the judge was wrong to assess the witnesses before him. And I think what was being suggested by, on the other side, was that no, it's got to be of principal relevance.
If, as my Lord Richards had pointed out when asking the question, if the judge had said, Jaggernaut is so obviously incapable of belief that Superintendent Philip should never have thought that this evidence was worth putting to the court, then in principle it would be relevant, yes. Going back to the...
I was a little bit concerned that we may end up getting bogged down in a set of an analysis of many authorities, which actually isn't fundamental to your case.
That might be right, my lord. If I can round up the test then, if we're talking about the spectrum between the discretion or the credibility of a witness and the statutory construction, evaluative exercise may fall somewhere in between. And each evaluative exercise is going to be different. It's going to be somewhere different on the spectrum. And I say this kind of evaluative exercise, especially when you look at the authorities about what the question is, what's the question to be decided, it's much closer to the statutory end of the spectrum.
Okay, well that's helpful, and maybe that will calm waters sufficiently to enable us all to enjoy our... We'll resume it too.